Welcome back to the Explainer, everyone. Now, if you've been following along with the course so far, you know we've already firmly established what evidence actually is. And fundamentally, we've established that evidence law is procedural law, right? It's not substantive law. But today, we're transitioning. We're moving away from simply understanding evidence as procedural law, and we're going to explore the really deep underlying philosophy behind it all. So basically, we are shifting from the what of procedural law to the why. Why does it even exist in the form that it does? Because you see, evidence law isn't just some random collection of technical rules. It's not just a bunch of arbitrary hurdles designed to make trials super complicated. Actually, it's a highly structured system built on much deeper societal values. Every single rule serves a specific purpose. And today, we are going to unpack those foundational values.
All right, let's take a quick look at our roadmap for today. Get your notebooks ready. First, we'll cover the philosophy of evidence. Second, truth, fairness, and reliability. Third, protection and system efficiency. Fourth, we'll look at when core objectives conflict. And finally, we'll tackle a constitutional dilemma.
Okay, let's dive into this. Section 1, the philosophy of evidence. Now this is the master key, folks. Every single procedural rule you are going to study in this course connects directly back to one of these 5 core objectives. Grasping them right now is absolutely essential for making sense of the rules later on. Okay, here they are. Number 1, the search for truth. Number 2, fair trial principles. Number 3, reliability of evidence. Number 4, protection against wrongful conviction. And number 5, balancing justice and efficiency. Make sure you have all 5 of those written down.
Moving right along to Section 2, truth, fairness, and reliability, the first 3 pillars.
Let's break down that first objective, the search for truth. Now, we have to remember that courts don't operate like scientific laboratories, do they? They don't have unlimited time or resources. They are human institutions. Because of that, they have to try and reconstruct past events as closely to the truth as reasonably possible. And they usually have to do this using incomplete and totally conflicting accounts. So evidence law doesn't actually guarantee absolute truth. Instead, it provides a highly predictable process to help courts reach a decision based strictly on the facts that are properly presented.
That brings us to our second objective, which is fairness in evidence law. What does this mean in practice? Well, it means ensuring both parties get a genuine opportunity to present their own evidence, and crucially, to challenge the evidence brought against them. We usually do this through cross-examination. It also means preventing an accused person from being forced to testify against themselves. And it means absolutely without question excluding any evidence obtained through coercion or torture. Think about it. Without these protections, trials would literally just be won by whoever has the most power or the deepest pockets.
Now, you definitely need to write this specific reference down. This principle is anchored directly in the Constitution of Uganda 1995, specifically Article 28. This article guarantees the right to a fair hearing. It is the supreme anchor, the ultimate authority for every single fairness rule you will ever study in Ugandan evidence law.
Okay, which brings us to pillar number 3, reliability. This exists because, frankly, not all evidence is equally trustworthy. Take hearsay evidence, for example. Hearsay is a statement that was made outside of court, but it's being repeated by someone else on the witness stand. It's basically a rumor. And courts treat it with immense caution because it is far less trustworthy than, say, an authenticated document or direct eyewitness testimony. Courts absolutely should not build serious decisions, especially decisions that might deprive people of their liberty or property, on shaky material like rumors.
And the statutory authority for that reliability principle? Write this down. It's the Evidence Act Cap 8, Section 30. That is the section that governs the treatment of hearsay evidence here in Uganda. Another great mechanism the law uses to ensure reliability is corroboration. For instance, before a court is going to rely on accomplished testimony, which you'll actually cover in depth in Module 8, it demands corroborating evidence, just to make sure the story actually holds up.
All right, let's look at Section 3, protection and system efficiency. Shifting our focus a bit to the reality of the courtroom, we find our fourth objective, protection against wrongful conviction. The consequences in a criminal court are just incredibly severe. We're talking about the loss of liberty, ruined reputations, or even the loss of life through capital punishment. Because those stakes are so high, evidence law responds with fundamental, non-negotiable safeguards. This includes the presumption of innocence, requiring proof beyond reasonable doubt, and the strict exclusion of torture confessions. For a perfect example of this, consider the landmark case of Akbar Hussein Gadi versus Uganda. That's Criminal Appeal Number 3 of 2013. In this case, the Supreme Court of Uganda strongly underscored just how important proper evidential foundations are before securing a conviction. It reflects a really profound legal principle. Our system would much rather risk an acquittal than wrongly convict an innocent person.
And that brings us to our fifth and final objective, balancing justice and efficiency. The reality is, courts operate with limited time and resources. If every single conceivable piece of information were allowed to be presented, trials would literally never end. So, evidence law utilizes strict rules of relevancy. These rules keep the proceedings focused tightly on matters that actually matter to the case. This is a bit of a sneak peek at your upcoming Module 2 studies on relevancy, where you'll find out exactly how much process is enough to be fair without making the whole justice system completely unworkable.
Moving to Section 4, when core objectives conflict.
Now, what's really fascinating here, and this is basically the climax of today's explainer, is that these 5 noble pillars don't always play nicely together. Truth, fairness, reliability, protection, and efficiency, they actually pull against each other all the time. Just consider this massive balancing act. On one side, you have the search for truth. But on the other side, you have the need to exclude illegally obtained evidence to protect fairness. Sure, excluding that improper evidence protects the integrity of the trial, but it might also mean a genuinely guilty person goes free. In that specific case, the truth gets sacrificed for fairness.
Let's look at another classic tension. Think about the desire to admit all evidence so we can find the truth, weighed against the need to exclude hearsay to ensure reliability. The rule against hearsay does a great job keeping shaky rumors out of the courtroom. But by doing so, it might actively block a piece of evidence that would have actually helped uncover exactly what happened.
And finally, think about how we balance making it easier to convict the guilty against maintaining strict standards of proof to protect against wrongful conviction. Setting the standard at beyond reasonable doubt makes securing convictions much harder, right? But it rigorously protects the innocent. So when you really get down to it, evidence law is fundamentally the law of managing these exact tensions. Every single rule you're going to study represents a societal judgment on exactly how to balance these competing weights.
And that brings us to our final stop, Section 5, the Constitutional Dilemma.
To wrap things up today, I want you to apply everything you just wrote down about truth, fairness, and the Constitution of Uganda to this exact scenario. Listen closely. If a piece of evidence would undeniably help reveal the truth, but it was obtained through a clearly illegal search, should a Ugandan court admit it anyway? Ask yourself, which objective should win? The search for truth or the protection of constitutional rights under Article 28? I want you to think really deeply about how the legal system balances these priorities and be ready to bring your absolute best arguments to our next class. We'll see you then.